All right, we're back and back over to you, Ben. Thank you.
Thank you. There is one last portion on this temporary care order. You'll see in the last bullet that a child can only be held. So if they're in custody, they can only be held at a secure facility. So this is essentially for lack of a term, a juvenile facility upon court order and recommendation by DCF. So that goes to that DCF recommendation question. That placement is necessary due to the risk of injury to person or property. So just to remember that. Now moving on, the risk and need screening. And I should have to say that the emergency care and temporary care process is, I wouldn't say a main feature of the juvenile procedure. It exists for the cases that are necessary to go through it, but my understanding is that there aren't large numbers of juveniles being taken into custody. So that is a procedure that's available, but I wouldn't say is a regularly used, if you will. What is regularly used, though, is the risk and needs screening. So this is in delinquency cases prior to filing a petition, a child has the option to engage in a risk and needs screening based on a subset of questions from the Youth Assessment and Screening Instrument, which is also known as the YASI screening tool. So this assesses the child's risk to reoffend. It's conducted by DCF or a contracted community-based provider like someone from a community justice center. Results are provided to the state's attorney and the child's attorney. And then this helps the state's attorney determine whether to file a delinquency petition or an off-ramp by making a direct referral to diversion and one of those community-based providers for programming. And typically that's done or that's required to be done when children present a low to moderate risk to reoffend. They're referred to diversion, and if for some reason the state's attorney feels otherwise, they need to go before the court and state on the record why that referral will not serve the ends of justice, which is sort of this amorphous term, but basically there's a good reason in this case that this child should not be sent there, and they have to go on the record to state that.
Representative Dolan and then Representative Bishop.
You mentioned the top point that the child has the option. That seems kind of strange.
So
how do they know that they have the option?
So there's a process to reach out to them that would be done by DCF or the provider to do that, and they have 15 days basically to accept that offer.
Okay.
Yeah.
Seems like that's an important thing if that then leads to the different off ramps that's based on what their score.
It's required in a youthful offender.
Okay.
But it's essentially an incentive for the child to say, hey, do this, and you might avoid this whole court process altogether.
Right. And is that a decision that's made with the parent or the youth just? So I'm just trying to understand how informed is the youth in making that decision?
So we'll get to this,
Okay.
but they are assigned counsel and a guardian ad litem at the preliminary hearing. So we'll get there.
Perfect.
Representative Bishop.
That addressed my question.
So a delinquency petition. For those of you that aren't familiar with court process at all, like I said before, this is like a charging document, but this is a concise statement of facts supporting the conclusion that the child has committed a delinquent act with a statement that it's also in the best interest of the child that the proceedings be brought. So that's what a delinquency petition is in its basic form. It must be accompanied by the law enforcement officer's affidavit, as I explained previously. When notice of the preliminary hearing is provided by citation, the petition must be filed at least 10 days prior to the hearings. And then the court provides a copy of the petition to DCF. It's made available to all parties required to receive notice by the state's attorney, and it must be done as soon as possible after the filing and at least 5 days before the preliminary hearing. Any questions on the contents of the delinquency petition?
Representative Goodall.
So the risk and needs screening the potential for risk needs screening can occur before. So the child and the representation doesn't get access to the petition, the delinquency petition, before they can make the determination as to whether they want to move forward with the screening.
Well, I think that's kind of up to the discretion of the state's attorney. I mean, maybe the state's attorney already has the petition ready to go, but it's not required that the petition be filed or presented to them before it's actually filed with the court. So the preliminary hearing, which is that arraignment, for lack of a better term, that's generally the initial appearance of the child in the criminal case. So the first time that they're going to be before a judge in family court. Failure to appear at hearing may lead to a summons to appear or an order to apprehend them so that they can appear. If a child is held in custody prior to a hearing, so if they've gone through that emergency and temporary care process, the preliminary hearing is held at the same time as the temporary care hearing. Again, expedited timelines, making sure that it can be as efficient as possible for the child, but also for the courts as well. And then those timelines are further expedited for merits and disposition hearings when the child is held in the secure facility. I believe that the merits hearing needs to be held 45 days after the preliminary hearing, and then the disposition hearing needs to be held 35 days after the merits hearing. So really expedited, that theoretically this whole case could be done in, what is that, 3 months, give or take? Again, counsel is assigned to the child prior to the hearing, and the guardian ad litem is assigned at the hearing. So what do you do at the preliminary hearing? This is when the child essentially enters a denial or admission of the facts in the delinquency petition. So they'll have a chance to consult with their attorney, with the guardian ad litem, and they can enter admission. If an admission is entered, so okay, I accept that I did these things. The court can proceed directly to disposition if the parties all agree to that occurring. And so the way that this could really happen in reality is if, listen, they all get together, the state's attorney, the child's attorney, the child's guardian ad litem, or their parents, and say, listen, this is what happened. This is what the risk of needs screening is. DCF has already done their risk assessment. They prepared this sort of case plan. If we all agree to it, we can go right to the disposition and the court can order that. So it can be done really quickly to get the kid back on track, so to speak, or it can take some more time. But are there any questions on the preliminary hearing itself? So then there are pretrial and merits hearing. The pretrial hearing is scheduled at that preliminary hearing. It must be held within 15 days of that first hearing. And then if there's no admission or denial or dismissal, excuse me, of that petition by the pretrial hearing, the court's going to set a merits hearing, which is the trial. Merits hearing must be held and all merits adjudicated no later than 60 days after the preliminary hearing, unless there's good cause shown. So again, all those expedited timelines. If a child submits an admission at the merits hearing, the court must engage in a colloquy to address the child personally in open court. So this is a set of questions aimed to ensure that the admission is voluntary, understood, and that a factual basis exists for the delinquent act. So for instance, Chair Lalonde, if I'm the judge and you're the child, I would ask you a set of questions that, do you understand why you're here today? Is your admission, do you know what you're doing? Is it a voluntary act? And the judge might explain what voluntary means. Do you admit to these allegations? And you'll go through the allegations. So do you admit, Chair Long?
I don't know why I'm here, no.
But that it would really be a real interaction between the judge and the child to ensure that the child really understands to the fullest extent possible the gravity of what an admission means. But if there is a contest of the merits, the court hears evidence and makes findings on the record. The state has the burden to prove delinquent act beyond a reasonable doubt. So that's another evidentiary standard. We have preponderance of the evidence, right? Which is
50.5%.
there you go. Then there's clear and convincing evidence, which is almost like a near certainty. And then there's beyond a reasonable doubt, which a lot of people say is beyond 90% certain. Essentially, like there's no doubt in your mind that this is it. And that is the same standard as in a criminal case to find someone guilty. So the same standard applies in this delinquency case. If the state fails to meet the burden, petition's dismissed and all orders are vacated. And then the court may proceed right to a disposition hearing if the parties agree to the disposition case plan. So you're seeing a theme here, like everyone kind of agrees what's supposed to happen. We're going to go with that. And then we'll essentially proceed to sentencing or disposition to formalize that order. So what is that disposition case? So this plan is essentially the course of conduct that the child is going to need to follow.
Some noise.
Sorry, just a quick question. So a child's attorney could ask for a jury trial.
Well, so there is no jury trial in delinquency cases.
Okay.
It's the judge.
It's just the judge.
Mhm.
Okay. Because I was like,
Because it's confidential.
because there's 60 days, so might not be able to prepare for
Exactly. So
that.
that's another difference between juvenile and criminal cases.
And if the court doesn't come to a conclusion within 60 days, is the case dismissed?
Well, what do you mean it doesn't?
Well, if you have 60 days from the start to the finish,
To hold the hearing.
to hold the hearing.
Right, right. And then there are timelines for the issuance of the decision, all that. I think it's within 7 days of the hearing and all of that. So yeah, it's all there. Typically, there can be extensions for good cause,
Mhm.
but the default are that 60-day timeline.
Okay, thank you.
So going to the disposition case plan, this is essentially the plan for the child. Or their sentence, but it's not a sentence. It's a plan of rehabilitation. It's based on a bunch of factors. One of which is the assessment of the child's medical, social, educational, vocational needs, the impact of the delinquent act on the victim and the community, and they can obtain a victim statement if possible to help with that assessment. A description of the child's home, school, community, and current living situation. So where are they at in their life? Do they have the supports at home to help pursue this plan, or is there something else that's going to need to happen in order for DCF maybe to help with them pursue this plan? And part of that, child's and family strength and risk factors, what the proposed conditions of juvenile probation are, the plan of services and responsibilities of the child and others, including the services required for probation. So maybe it's to complete diversion with a community justice center. There are certain benchmarks that they'd have to hit. That would be in the probation certificate, and they'd have to comply with it. Now, if the child is in DCF custody, there's a permanency goal of the child and how it is achieved. So a permanency goal is sort of after these temporary care things. It's a long-term goal of sort of their living situation and their status that can be informed by this. So a lot of that can be reunification with family, adoption, guardianship, or other sort of family-oriented goals that's a part of that permanency goal. So this case plan can include the parent and child contact that's recommended by DCF, request for child support if the child is in DCF custody, or if DCF recommends a transfer of custody. Also a psychosexual evaluation, if it's clinically indicated and the child is charged with a sex-related crime. Now, it's important to know that the case plan cannot be used or referred to as evidence prior to a finding of delinquency. So it's really not there to kind of hold over somebody's head. Again, it's that rehabilitation, that assistance goal that this is there for. And it's the same with the risk and need screening. That can't be used against you in the process as well. So any questions on the contents of the case plan? So then there's the disposition hearing. It's to determine the disposition of the case where the child has already been found delinquent. This is like the sentencing hearing in a criminal case. It's held no later than 35 days after the delinquency finding. If the disposition itself is contested, so child's attorney may contest the plan. And if it is, then they can present evidence as to why they think the plan is unfair or maybe doesn't provide the help that's necessary for the child. Hearsay is permitted, so you can have out-of-court statements offered for the proof of the truth of the matter asserted. And authors of reports can be questioned. So if you had, say, a DCF report that was submitted the author of that report could be questioned on the stand about that, but the underlying sources of information is confidential. So if DCF talked to family members in order to obtain the information in the report, those sources would remain confidential and cannot be disclosed in this process. If there's a termination of parental rights that's part of the disposition plan, termination must be supported by clear and convincing evidence. And other issues, their standard of proof is that preponderance standard. And the reason why is because if you're talking about termination of parental rights, that is one of the most serious things that you can do when it comes to a parent and a child. So you need a higher standard of proof in order for it to pass constitutional muster, essentially. So that's why it's a higher standard for those issues in comparison to others. If the termination of parental rights and custody to DCF is sought, the court considers the best interest of the child pursuant to section 5114 of this title. And there's a whole list of factors that inform the best interest of the child standard.
Okay, let me ask a question. So the termination of parental rights, does that become very much a separate hearing, a separate consideration?
It can, because after this disposition order is, let's say it's ordered, those conditional custody orders or whatever, there are review periods. And so those would take place kind of separately after the fact. But no, I mean, this would govern this process. Yeah.
Yeah, Representative Bishop.
Following up on that, but it would seem to introduce new parties, if you will, the parents whose rights are being terminated. So it would seem like some sort of additional or separate proceeding or certainly extension of timelines would be involved.
Yes, it could potentially do that. And that's why there's parties that are considered necessary and proper to the hearing. They can motion in to be given party status. So that could be a parent. And then if there are a lot of issues and information to gather, that's probably pretty good cause to extend the dates of this timeline. So there is room to do that within the process. Any other questions? And so the disposition order itself, it aims to achieve the statutory goals of providing for the child's supervision, care, rehabilitation, community protection, accountability to victims and community for the offenses committed. And again, to develop those skills necessary to make a child a productive member of society. So those are the goals of the disposition order. There are several options at the court's disposal. They can place a child on juvenile probation under DCF supervision. Custody could be given to a custodial parent, guardian, or custodian. Again, I mentioned before, there are those limitations and conditions that include 6 months protective supervision. You might ask yourself, well, what is protective supervision? Well, that's when DCF can kind of drop in on you and make sure that everything is going okay. But there has to be, it can't be done in the middle of the night. It's all kind of reasonable hours. At least it's supposed to be done that way. Custody is another option is custody being transferred to a non-custodial parent, relative, or person with a significant interest or connection to the child, subject to the same conditions as above, or custody is transferred to DCF. You could also terminate parental rights, as we were talking about, and custody and guardianship can go to DCF, and it could pursue adoption for the child. There can be a permanent guardianship order that's issued. Referral to a community-based provider like the CJC or DCF's Balance and Restorative Justice Program, which is also known as the BARGE program. And a child can be returned for disposition hearing if the provider declines to accept the individual. So for whatever reason, maybe they're not willing to accept responsibility, which is sort of a precondition of these diversion processes. So if they're not willing to play ball, the CJC is probably going to refer it back to the prosecutor and talk about a different case plan here. Or if the child fails in the program, they engage in it and they just don't meet the benchmarks and they're unsuccessful. So now we're going to juvenile probation. Because a lot of times there are people that ask, okay, so what happens? Like, is there any accountability for these folks that are subject to these case plans? And the short answer is yes, absolutely. And the purpose of probation is to ensure to the greatest extent reasonably possible that the kid be provided with a program of treatment, training, and rehabilitation consistent with the protection of public interest. So that is probation and the purpose of it. So how do we really get down to the nitty-gritty? The court issues this probation certificate containing the conditions, and it must be signed by the juvenile and the custodial parent, guardian, or custodian after it's fully explained and the consequences of any violations are outlined. Now, it's interesting. It does say that this certificate is not invalidated if the child refuses to sign. So for whatever reason, there was a policy decision made that as long as the parent signs it, it can be enforced because they're often responsible as well for the child's actions. And these conditions may include community service, restitution or reparation to the victim. So maybe they'll have to work to pay something off. Maybe they'll have to rebuild a fence, something along those lines.
So what if it's an 18-year-old who doesn't sign because presumably they don't have the parent?
It's different if they're 18.
So they have to sign, it would be invalid if not.
Right, but at this point, if they didn't sign it, then they'd probably have to go back to a disposition hearing
Okay,
and readdressed.
all right, thanks.
Restitution and reparations, competency programming, so some skills level training, some education goals, prohibit the purchase or possession of weapons or ammo. They may have to report to the probation officer. They may have to receive visits from a probation officer and be open to any inquiries by a probation officer. They may be ordered to reside at home or some other court specified location, potentially if there are, victim issues and kids not needing to be around certain people. They can also attend or reside at facilities designed for educational or vocational training or a juvenile facility. So they can be essentially detained, for lack of a better term. Or they can have the condition to faithfully work or pursue vocational training, treatment or counseling needs, or any other conditions that are reasonably related to rehabilitation as determined by the court. So those are all the various conditions and tools the court has in probation. So what happens if you violate probation? So the court, the state's attorney, or DCF have discretion to enforce a probation violation. And I think it's worthwhile noting that my understanding is the DCF has a lot of discretion to enforce these violations because ultimately it's going to come from them. If the court knows or the state's attorney knows. So it's really, they're the first line of defense or mercy, if you will. A formal violation can only be established when someone is found by a court to have violated probation or another delinquency has been adjudicated or they've been convicted of a crime. So all of those constitute violations. Then there is a specific procedure, but it's kind of similar to the emergency and temporary care procedure. So keep that in the back of your mind as I go through this, that the court can issue a summons to appear or order apprehension and placement in a facility so that they take you in if there's a serious enough violation. The probation officer can authorize a law enforcement officer to do so by providing a written statement setting forth the violation. So that's another way to do it. Then there's a pre-violation hearing that's set, and it's conducted the next day after the child is apprehended. And this is essentially a probable cause hearing. You can present evidence and witnesses to establish that there was probable cause that a violation occurred. And then there's a violation hearing soon after, which is the full evidentiary hearing. It's held at the earliest possible time if the juvenile is in custody. Notice is sent to both the juvenile and the adult signatory of the certificate. There's right to counsel, and that violation must be established by a preponderance of the evidence, so it was more likely than not to have occurred. And again, disposition. So what happens? What's the court order at the end of this hearing? If a violation is found, and established, they can modify probation conditions, or order any disposition alternatives according to one of the statutes, which is the one that dictates conditional custody orders. So you can either be released to your guardian, a non-relative or non-relative, but there would be certain conditions and limitations subject to that and that whole process that follows. So those are the tools available up to the court to adjudicate a probation violation. So youthful offender. So everything we just talked about was in the delinquency context. And as my colleague Eric Fitzpatrick said, youthful offender is kind of a blending of the juvenile process and the criminal process. So what are the key differences from the delinquency process? One is that it's pretty similar, but the risk and need screening is required to be considered for a youthful offender status prior to that status hearing or consideration hearing. And it has to be completed within 15 days of it being offered. So if you want to reap the benefits of the juvenile system and you're a youth of a certain age, you have to do this risk and need screening, or else we're not even going to consider it. So that's a requirement. Any bail conditions. So let's say the charge started in criminal court and then there was a transfer. If there was an arraignment and bail condition set on that individual, they stay in effect until the family court takes jurisdiction. So if the family court has that consideration hearing and ultimately decides that we're not going to grant you youthful offender status, the bail conditions still stay in effect. Youthful offender status hearing is held within 60 days of that transfer from criminal court. So again, we're going to make sure that we get you into the juvenile process within that 2-month time frame. Any custody transfers or orders terminate at the youth's 18th birthday because at that point they're an adult. So custody doesn't really have the same effect for an adult as it does for a juvenile that's 18, that's under 18.
So I have a question about that. So let's say, you know, within 6 months of their youth's 18th birthday, they have this process, yet under criminal court, whatever sentencing there might have been would have been longer than that. So do things just terminate at 18? Is the person just like, you know, they're free from whatever oversight and responsibilities that they had, or?
Yes and yes and no. So if part of their disposition case plan was included custody orders, those wouldn't be in effect anymore, but the other conditions of probation still would be. So if they had to report to DCF probation, they still have to do that, but you don't really have parental supervision or, you know, a custodian looking after you. So yeah, this is sort of that blending of you take on more responsibility for yourself to pursue these objectives because you're a youth. So sort of an adult, but still sort of a kid.
Mhm.
Does that make sense?
It does, and it doesn't. I mean, for me, when I think about our, you know, our concepts around raise the age and the science behind, you know, brain maturity and stuff. So on one hand, we say we should treat you like this because you know, you're still developing. And on the other hand, well, at 18, sorry, you know, not sorry, but, you know, those orders terminate. It's just an interesting dichotomy for me.
Sure. Again, in this context, both DCF and DOC, so the Department of Corrections, are responsible for the disposition case plan supervision, but the youthful offender is placed in juvenile probation. So their direct supervisor, for lack of a better term, is a DCF worker, but DOC has knowledge of the case plan and they can take action if it's necessary. But I would say that since they're in juvenile probation, DCF is really the first person or entity that they would work with. But DOC is aware of what goes on. And probation violations can lead to a modification or revocation of that YO status. So this is the carrot that can be pulled. So if you don't play ball and you don't do what you need to do, we're just gonna kick you to criminal court, you're gonna enter a guilty plea, and you're gonna go right to sentencing. And that's the real incentive for those kids. And again, DCF or DOC can detain someone who, if they're 18 in an adult facility, supervision can be transferred to DOC in this process, and they can be electronically monitored. And if that youthful offender status is revoked, the criminal division, like I said, enters that guilty conviction because you've already admitted in the juvenile process to get to that disposition case plan. So technically the merits have already been done. So you go right to entering a guilty plea, holding a sentencing hearing, and imposing a sentence.
So if the 18-year-old is not youthful offender, but is in the juvenile, can they be held if something comes up? Are they able to be held in prison? Or is that different?
If they're 18, yes, they can be held in an adult
Age,
facility.
it's not the status of whether they're in juvenile or youthful offender, okay. Representative Hudson, no, thank you.
Sorry, I didn't know you heard, I didn't know if you saw her.
Thought as I'm listening to this, it strikes me how important adequate representation is and how the very, very consequential decisions that are being made by youth who we've said in other cases, as Representative Wood was just saying, lack the full capacity to understand and comprehend and make these very consequential decisions. It's so important that they have someone representing them and guiding them, or more than one person ideally, to help them make these huge decisions. And
they do, because even in youthful offender, they would still go to that preliminary hearing if they're granted youthful offender status. And they'd be assigned counsel and a guardian ad litem if it's
right,
appropriate.
right. So assigned counsel is different from having robust representation. No shade to counsel, but like, we know that, caseloads are gigantic, and we have a deficiency of public defender, it's a lot of work for the defense counsel. And when we think about investments in public safety, I just want us to be thinking about the needs of these children and how we're funding the system that is supposed to rehabilitate them.
To make it a question, you should say, don't you agree?
I would say that's a policy decision.
Then there you have. All right.
And then finally, if the youth is on probation as a youthful offender prior to age 18, once they attain 18 years of age, the family division reviews the case to determine if they should retain jurisdiction. So there is a review that says, okay, are we done here? If we're done and they've done enough, we can kind of discharge youth and dismiss the case. But if there's still work to do, they can extend that jurisdiction up to 22 years old. Any questions? that haven't been asked?
Now, then Representative Dolan.
What's their record? So they are found delinquent, they go through the merits thing, they go through probation. But on the other end, what's the record when they?
And they've completed everything.
Yeah, let's say they.
in the juvenile
And
context.
let's do juvenile delinquent case first and then do youthful offender.
So if they are granted youthful offender status, they are essentially considered
Okay.
a delinquent. They
Okay.
just have a different age.
Yeah.
Or crime. And their record, there would be no record. It's sealed.
So is it sealed or is it like, do they have a record? Like if they were, let's say they were arrested when they're 30, can a cop, go and look and see?
My understanding, and I might defer to Eric on this if he knows, but is that it's sealed and it can be accessed for certain very specific law enforcement needs. But by and large, it's as if there is no record.
And is the record the criminal charge? So let's say you're charged with an L&L, and you go through the delinquency, if you're now 30 and it's sealed, but is it that charge?
Well,
Or is it that?
it would be the delinquency process, but it would probably also show the law enforcement contact, so there would be a police report as
Yeah.
well. But again, I think that would be a better question for law enforcement, but I do understand that there is access to certain information, but and it could include from the first law enforcement encounter, all the way through the delinquency process.
Okay. Thank you.
Yeah, Representative Bishop.
One last question. There's considerable discussion in Vermont about the workload for our court system. You discussed in quite a few instances of timelines.
Yeah.
Do you have a sense as to the court's current ability to abide by those timelines?
I can't speak to that right now.
Yeah, we'll have Judge Stoney and, well, actually, we may have him in when you guys aren't
We're
here,
not
but
here.
we have other people that we can ask that question, make sure. So thank you very much, Eric and Ben. So we've kind of learned the statute and what's supposed to happen, and the next meeting witnesses, we're gonna find out what's really happening, what is good, what is good and bad about the system, because there are good aspects, obviously, but there are other issues that we learn. So we're gonna start with Matthew Bernstein and Lauren Higby, Office of Child, Youth, and Family Advocate. Join us. Thank you.
Yeah. Yeah. Gladly take it. Just trying to get into the Zoom meeting here. You'll wait 1 moment. Yes.
You're actually leaving.
No.
Okay.
Forget it.
I thought you.
I know, no, it's all good. It's all good.
Can you get in? They lost their church. Because for some reason it's not complete.
We want forward the language.
You have it in your email. I want to scroll down the last time I sent it. Scroll down. and send it.
Oh, it's always said, it's always said. If I took off my constituents, what a child could do.
Yeah, that's what I said.
Sending the link as well.
It's a 22.
Just see real quick. Sure, Nate, whatever. If you can can you send like an actual invite? Sure.
So while we're waiting for them to get online, we're probably not going to get through the witnesses that we have scheduled for this morning. Might, yeah, we'll see. But so the plan is that we will come back here after the floor. We have witnesses at 1 until 10 minutes before the floor. Floor, it looks like it's gonna be very short. So whoever we don't get to this morning, we'll come back here after the floor and finish up those witnesses, just so everybody knows that for planning purposes. There, I bought you some time.
Thank you.
Matt did a send link for, it should have a meeting password though too.
Now I see.
Should I have?
Tim's and,
Yeah.
yeah.
I got it.
And I
That should be,
told- yeah, and I
and you
told-
type in Margaret.
All right. Okay, cool.
All right.
All right, thank you for your patience, everybody.
Presentations also on the committee pages.
Yes.
All right, great. Yes. Matthew Bernstein, Child, Youth, and Family Advocate for the state of Vermont.
The deputy advocate with OCYFA.
And we have a lot to talk about, so we are going to jump in. So I think some of you are probably not as familiar with us as others. Some of you are very well familiar with our office. We're about 2 years old. We're an independent state office that engages in individual and systemic advocacy on behalf of children served by DCF is the way we're framed, but the statute focuses on child welfare and juvenile justice. Emphasis on independent. This issue that we're talking about today has become really charged. There's a press conference this afternoon. I believe you're going to hear some introduced legislation. I think youth are being used as tools, frankly, for various groups to achieve their own ends. Our job here is to represent the interests of children, youth, and families. So that's why we're here. Second, we're charged with examining systems as a whole and articulating youth-centric reforms. These happen to also save the state significant dollars, so we're going to talk about that. So they are good for government, but it's children and youth first, and government efficiency is one of the many benefits that flow from that. And then finally, we focus on racial and social equity, and you're going to hear a fair amount about that in our presentation today. And that's all of these are from our statute, which is 33 PSA Chapter 32, which is a very well-crafted statute that many of you in this room worked on. If I might say my unbiased, non-pandering personal opinion. Okay. Is this the second slide? Yep. All right. So here's what you asked us to talk about today. These rubrics here are going to repeat a couple of times, and we'll frame why. But this is what we were sent in terms of what you wanted us to talk about, and I believe that's what other folks will talk about as well, and that's what Ben was talking about. And this is the second set of questions. So like everybody else who you hear from, we are going to take this in the direction that we want to take it. I think part of the problem is the way these issues are framed, and raise the age has come to stand for the entire juvenile justice system, right? So one thing we want to do today is distinguish raise the age as is going to go into as phase 2 is going to go into effect in April 1st of 2025, as well as phase 1, which is already in effect, from youthful offender, from the big 11+3, from facilities, youth prisons, etc. Those things are, intimately related, and all of those issues are very important. But what is going into effect on April 1st of 2025 is the second part of Raise the Age Act 201 of 2018. And it's important to understand how that's different from and overlaps with those other rubrics I mentioned. So if that's still confusing to you, hopefully our presentation will clear that up a little bit. So we've broken down those questions on the previous 2 slides into 4 different categories. Charging options, which we were talking a lot about this morning, services and supports, restrictive settings such as residential care, residential treatment programs, crisis programs, bridal retreat, the Red Clover Secure Program, and the proposed Green Mountain Youth Campus. And then data to assess all of these. So basically, here's where some of the repetitions, First, we're going to sort of define each of those 4 things real quick, and then we're going to kind of apply them to the questions that you asked us to look at. So, you've heard a lot about this morning, so we don't need to, repeat. But essentially, here's one way of breaking out the different ways in which juveniles can be charged. There's delinquencies, right? They're heard in the family division. They're confidential. Youth-oriented means, the whole idea that young people's cases are heard in the family division is that, the family division, from judges to probation officers to DCF workers, are experts in youth development, right? Or at least recognize youth development, youth brain science, et cetera. And that's one reason we have confidentiality, right? I don't call it the Big 14 because the 3 adult charges that were added in S58 last session are not treated the same as the other Big 11. The minimum age is a lot older. I also think that frankly, just partly why I say Big 11+3 is that the 3 charges that were added last session, at least one of them really criminalizes victims. So the charge I'm talking about is 16 and up. young people who are accused of trafficking drugs can now be charged as adults. And what we know from the systems that we work in is that, you know, more often than not, those youth are victims themselves. They've largely been in the child welfare system, and they are taken advantage of by older adults. I think it's a huge mistake to charge them as adults. We said this at the time. That's a separate issue. I will say, if you're interested in an example of what I'm talking about, I would look up the case of Isaiah Rodriguez, who was a young person who was murdered in 2022, who is from Massachusetts, who was 17. He was shot, I think, 30 something times. So we'll talk more about that. Okay, so sorry, I don't want to get off a track. Youthful offender, you've heard a lot about as well. And I think the points, the smaller bullet points here are, you know, what I said earlier, which is both the Big 11+3 and the youthful offender statute are not related to the April 1, 2025 implementation. Phase 2. Repealing that or prolonging it a fourth time will not affect Big 11+3 and youthful offender. It will not limit prosecutorial discretion to people for major crimes as adults. What's going into effect on April 1st, 2025 is primarily pertains to low-level offenders. And I think that part of the conversation has really been missed. Almost all the young people we're talking about with Raise the Age, actual Act 201 Raise the Age, are there for low-level charges, and they will not commit another offense. And if they receive appropriate services, they will become productive members of society. And that's in fact what the law says. And in fact, there you go. So this is from the Act 201 implementation plan from 2019. This is cited in our sources at the end. We had some incredible high-level national expertise developing this report, the Act 201 implementation plan, and I think Judge Davenport is in the room and some others worked on this. This is a really, really high-quality plan, and if you haven't read it, it walks through all the value of Raise the Age. It walks through how to implement it. It walks through the data we need. It answers really a lot of the questions on the first couple of slides. So I highly recommend taking a look at that. Okay, so just this is where we start to get a couple of repeats, but essentially what this slide is supposed to stand for is what I just said. For bullet 1 and bullet 3, the 17 or under charged with a misdemeanor, or the 18-year-old charged with a misdemeanor, essentially Raise the Age says there's nothing magic that happens when you turn 18 from 17, where you mature and your brain develops all of a sudden, right? Those, you know, and each youth is different. So essentially, you know, those are both young people who should be diverted if possible, given supportive services, and ultimately the goal is to discharge them out of the criminal justice or the juvenile justice system. For the folks that are charged with violent felonies, whether or not they're a Big 14 offense, in the charging options, for folks that are charged with a violent felony that's not a Big 14 offense, I think the data shows, and we don't have it today, we hopefully will have it soon. I think those are almost 100% charged as youthful offenders, but I'll say I don't truly know, and I'm sure the prosecutors and others could answer that. If it's not 100%, I think there's a high percentage that are charged as youthful offenders, but I don't know. I will say I don't know. And just keep in mind, this is just charging options, right? So we're going to talk about services and supports in a second.
Before you go on,
Yeah.
actually, if you could back up
Yeah.
for me, could you comment a little bit more about how the justice system can unintentionally interfere with the natural desistance process? Is that something that you can address?
Yeah, I mean, I think there's other experts that are perhaps more qualified. I think a lot of this is in that implementation report. I mean, essentially the idea is the data shows, and we have some slides later talking about this. You know, the data shows that most young people who commit low-level offenses, you know, are doing so because of, first of all, group behavior, right? They're often, you know, peer pressure is sort of a real thing. You know, inability to restrain impulses. You know, often it's substance use issues. And you know, what they often need is positive reinforcement. I mean, the data shows that connection with a supportive adult, at least just one, can often really, like, there is high quality data to show that connection with a supportive adult who can kind of show a young person how to be a productive member of society and the value in that, and long-term planning, right? That plays a huge difference. And so if you over criminalize them too soon and don't recognize that, they want to be successful, they sort of can get dragged down into these systems, especially if there aren't supportive community-based services available to help them along that process, right? And a lot of what Vermont, we'll get to this, has on offer is sort of medium to deep end offerings and insufficient community-based supportive services. And so I hope that answers your question.
Yeah, no, I just think it's, I'll turn to Lauren in a second, but I think it's important with what we're learning the next couple of days to understand why do we have a separate juvenile justice system? That's why I asked that.
Yeah.
But yeah.
I would just add that most of the research that is out there in regards to recidivism rates and reducing delinquency behaviors, the number of interactions with the juvenile justice system, and as you increase the intensity of that interaction with the juvenile justice system, increases your likelihood to continue to have involvement with the juvenile justice system and then the adult system. So I think also part of this discussion is the impact of having a really comprehensive juvenile justice system is going to help our adult corrections as well.
Appreciate it. If you could identify yourself for the record, I don't think you did.
She did.
I did.
Oh, you did. I missed that. I was somewhere else. Thank you again, Lauren. Go ahead.
Okay, so good segue into, into supportive services. And this is all backed by data. So community services, should say, and supports, I guess, leverage federal money, reduce racial disproportionalities, reduce recidivism. I mean, that's a key one here. And this is backed by data. We have citations at the end. And protect disability rights, which we're also getting to. And they truly do save money. And one reason they save money is because of federal reimbursement. So the two key, we'll come back to this, but the two key services here are Medicaid and Title 4E of the Social Security Act. Medicaid is, Barge, for example, is a Medicaid funded service. And long-term, this is a complicated issue. Vermont, one of our key recommendations is that Vermont should invest in some real high quality, high level expertise in developing Medicaid programs, particularly in this aspect for juvenile justice, also on the child welfare side. It is enormously complex and challenging. It is not simple. And it goes all the way up, to our 1115 waiver and to some really high level federalism, regulatory stuff that is challenging. But there is a lot of value there, meaning there are millions of dollars in federal money that we could draw down to create supportive services. So the other emphasis from here is that it's really on DCF and the Agency for Human Services to develop these programs. I think what's been frustrating for us and me in this bigger conversation here is to hear DCF sort of sometimes fail to acknowledge the extent to which programs happen because they are created and because people work really hard to create them, right? And right now, what we see is a lot of energy, effort, money, time, resources going into creating the deepest end of the system, the locked facilities, and really insufficient resources at the shallow end of the system, at the supportive end. This is not just a question of keeping communities safe, because kids are more safe in their communities, but it's also really, these are constitutional issues. These are federal statutory issues. These are state statutory issues. These are very significant rights that children have to be in the least restrictive setting. And it is really incumbent on DCF, AHS, the state, all of us to develop those services and not simply, put our efforts into the deepest end of the system.
Representative Cole.
Yeah.
Thank you. I'm wondering if you have an example of a state who's doing it really well and who is doing or is having the most success too in drawing down those federal funds as a result of their good implementation of these.
Yeah, I should probably get back to you on that. I mean, places, I will say, to answer your question in the reverse, it is a real challenge in Vermont being small.
Yeah.
To bring in providers. These are real challenges. So we don't want to be sitting up here saying this is simple. I think what we're frustrated with is the efforts that are put into it, right? I don't want to say California because no one wants to hear that. But, I mean, in places that are, I mean, even New Hampshire actually does a decent job. Joseph Ribsam used to be the director of their DCYF, and he brought in a number of Medicaid providers. He now works for the Annie Casey Foundation. You'll see an example later of where Maine is failing to do so, unfortunately. But New Hampshire has made some good progress. So you don't have to go to California, but we could certainly get back to you on.
I think I would look at Baltimore system since Mr. Schiraldi helped write the 201 implementation report. So he has a breadth of knowledge really of best practices and what works well. I would just answer too in general as we get back with specifics that if you look at the news headlines, we're really in this interesting national movement of juvenile justice reform as we have more and more lawsuits pertaining to residential facilities, to the risk of harm in juvenile justice and locked detention facilities. Really, the US government and Vermont and many states are at this critical point where we have to reevaluate what it looks like to be a successful juvenile justice system.
Yeah, I want to underscore that. I think it's a great point. Really nationally, there's a lot of momentum to offer these supportive services. I think also nationally, there's been a regression and there's been a real move to treat younger and younger kids as adults, which is troubling. There's both, right? But there is a lot of national support and insight into this, and that is another critique I would say is that we don't, because we're a small state and have few resources, we really need to bring in out of state folks, and it's not impossible. There's a lot of really important experts out there. So okay. So here's some of what we talked about before, in answer to your question, Chair Lalonde. Early childhood trauma plays a huge role here. You've heard of ACEs. I think I want to emphasize the second bullet here. Assessments. You heard earlier about the YAZI assessment. This is another area where I think Vermont has a lot of room for improvement. We would like to see the CANS assessment, the child. Oh no, I stepped in.
Adolescent
needs survey. Anyway, the CANS is a nationally recognized evidence-based assessment that is in use by other departments in Vermont. We are assessing needs of youth is crucial, right? And it's crucial to making sure they're in the least restrictive setting, to getting them services that they need, to making sure that you're spending money in the right way. And that's an area where I think we really could use some more insight. And again, actually, there's some insight in New Hampshire that I think we could draw upon.
Just can ask what other departments?
Good question. Even
DMH is using CANS, I would say the majority of other child welfare jurisdictions across the country use CANS because it creates this uniform survey, and Vermont could tailor the items. And then you can reassess the child or youth over and over again to really see how you're moving that dial. And then we could use the cumulative data to see where we can adjust our system more effectively given what it demonstrates.
Representative McGill.
We use it in the runaway and homeless youth sphere, both for HUD and the Family and Youth Services Bureau's program. So that's being used in Vermont for that population.
Right, and I think that's part of the value is, if you have that apples to apples comparison, you can start to really assess sort of cross issue, right?
So you think that CANS should be replacing YAZI? Is that
I mean, I think it's worth looking into. I think that our assessments need a great deal of improvement. I think there's a lot of experts out there who, could bring some insight, but the CANS is one that we both have experience with in other jurisdictions and, and know that it's, very well respected.
Right, and I think that there's opportunity there as we assess the entire system of care that isn't only responsibly placed on DCF, right? If we see DMH in various ways is using the CANS, and then youth that are exiting from DCF care are participating in the runaway homeless youth programs, then we can really start to see interesting continuity of care and assessment and follow these youth through years and years and years. And then that's where we start to identify the upstream. I know people love that phrase, right? The upstream identifiers that we can target.
Respecting their privacy, of course.
I am in the bubble.
Yes.
So to,
No, and that's a real example too. I just wanted to say, like, that's not a hypothetical. In other words, children who are in the juvenile justice system and often, will have crossover child welfare involvement are discharging at 18 to homelessness, right? And Representative McGill knows that well. This is, this is not an insignificant number of children are in that position. DCF is, I'm not trying to put that all on them. DCF is working hard to prevent that. It's structural housing issues that we all are familiar with. But I think that, it's something that we all want to obviously prevent. And I think, assessing needs is a crucial part of that. Sorry to cut you off.
no, Representative Arsenal.
I wanted to, two things. One, on that point, as I understand it, in the state of Vermont, we don't currently have the ability because of IT infrastructure to know the number of youth who are intersecting with both DCF and the judiciary.
And the juvenile justice system?
The juvenile justice.
I don't think that's quite accurate.
Okay, that'd be great if it's not.
We are actually working on those numbers. Through the judiciary, they can run reports about.
And do those, but like Odyssey and DCF IT isn't talking to each other. I'm saying.
If you're talking about the filing of a CHINS case, Odyssey can do both filing of a CHINS case. I believe, run a report that is youth who have both a CHINS petition and a juvenile justice petition.
Great, that would be great.
I appreciate the suggestion.
You can't go to DCF for that information.
Yeah, and then I was just wanted to clarify the use of Yazi or CANs. Is that a DCF AHS decision or is that a judiciary decision?
Good question. I believe that is a.
I would say,
DCF
yeah, the
decision, but
department
I'm
and agency would have that discretion to use it.
Okay.
There might be like licensing considerations, things along those lines to consider.
Thank you.
Yeah, I'm not entirely sure.
Just to clarify, it's not in legislation that we've designated what they have to use.
I believe it is in legislation, and again, there's other folks better qualified. For example, if you're placing, I do know that it is in statute that if you're placing a youth at the Red Clover Lodge facility, the judge has to, there has to be an assessment of need. And it's deemed that they require that level of care. And so, but it doesn't, I don't think it names a brand name.
Yeah, we don't have there's no system named.
All right. I think I'm gonna, keep going here. So, to talk about some data here, frankly, I don't think I think it is simply factual to say that DCF is intentionally presenting data that blends delinquencies, YO, et cetera, at least delinquencies in YO. It's been really frustrating in all of the conversation about raise the age to see the lack of clear data. And, it's not a conspiracy, but I think that as I said at the beginning, I think this issue has really become it's really become a vehicle for folks to push policies that they would like to see accomplished. And I think sometimes the factual way in which the system is working, particularly from a youth center perspective, gets lost in that. So, that may not be helpful to cast aspersions because I think it doesn't matter. The point is that we don't have great data in front of us, right?
I would just add, as we were listening to Ben earlier, right, he really outlined the overlapping responsibilities throughout the juvenile justice system. And so when we cannot parse out a true raise the age youth to understand the capacity issue that has on DCF or the judiciary, then there is not enough evidence to delay it any longer or to repeal it.
Right, and that goes for a couple other subject matter areas. There's sort of like a rush to policy simultaneous to we don't have data on this. And I just want to emphasize, in case you were going to ask Representative Arsenault or not, the reason it has nothing to do with not having a data system for DCF for this. It's really just a question of, it's a question of will. So we do have some data though. So we're going to run through it. So here's some, this is in the Columbia Justice Lab report from last year. As you see at the bottom, it is from a federal reporting that DCF submitted as you see, it is, I believe those are by a fiscal year. I think those are fiscal years.
State fiscal years.
Right,
Yeah.
state fiscal year. So it's also confusing because you get calendar year data, federal fiscal year data, and state fiscal year data. Anyway, and so this needs updating for 2023, 2024, 2025. What this is the number of youth on probation is counted one day. It's a single day count. The orange is when 18-year-olds came onto DCF caseloads, came into the family division for Raise the Age phase 1, starting in it was FY 21, right? So it was July 1 of 2020 when 18-year-olds came on the family division. So state fiscal year can be useful in that sense for Raise the Age purposes because it started at the beginning of state fiscal year 2021. So anyway, what you see here is interesting because you'd expect to see, given that you're adding a whole other age category, right? You'd expect to see these numbers rise no matter what, right? The fact that they fell is, it could be pandemic related or whatever, but I think the point is that it's, it did not add a significant burden to DCF probation caseloads, right? And there's different ways of talking about the data because, there's charges filed, there's probation caseloads, and this next slide talks about DCF custody as a result of delinquency. So this is this somewhat Vermontian anomalous statutory framework that we have where in general, children are taken into custody here, I think for juvenile justice much more than in other places. But regardless, so these are youth for whom DCF is the legal parent, essentially. And this chart, as you see from 2009, represents some of those national trends. It represents state trends, and this is real, this is that brain science and that understanding of what youth need really in action. And this is good news. It's a long-term trend, and it is really helpful. But it also makes the point that DCF was not overburdened by phase 1 of Raise the Age.
And that allows us to expect they will not be overburdened by 19 months.
Right.
Represent steady.
Do you think that a lot of the problem is the outdated computer system? Because it was, back when I worked at DCF, there was an effort to try to fix it. It didn't work. So in their defense, I think a lot of it is what they're given for tools.
Mm-hmm.
So because the computer system's a nightmare.
Yeah.
It's so outdated.
I think that's true, but I also think it's become a bit of so we should fix the computer system.
Well, they tried it and they put lots of money into it, and then it didn't go forward. It stopped, and I never could understand it, but whatever.
Yeah.
I think because there was so much money put into it, I think they stopped. But instead of continuing trying to fix it, but I think that's a lot of it is like the data.
Yeah.
We'd
love to come back and talk about that some other time. I think it's a complex issue. Again, I think the short answer is that's become an excuse. And this is one reason why I'll give you one of our recommendations on the data system, which is to implement it in a much more smaller chunks than they are. So right now they're going to put out an RFP essentially for the whole thing. And what the data shows for software development, that is the bigger the project, essentially, the less likelihood of success. This would be a great issue for something like you could put out an RFP for a small chunk of the system rather than the whole thing, and I think you'd be more successful. It's a complicated issue, though, that we'd love to come back and talk about. Okay, so this is some data about this. Basically, just compares delinquencies and youthful offender charge. These are charges. So state fiscal year 2023, there were 1,009 total juvenile justice filings. That breaks down into about 700 delinquencies and 315 youthful offenders. It went down a little bit in FY 24. The rates are up a little bit in FY 25 so far. We obtained this last week. This is just sort of to give you a general picture of how data can be broken out and should be broken out. Ideally, you'd have ages within this, and we have a request in. Hopefully, we can come back and provide you this breakdown by ages for these recent terms. What we do have is data that we got last year, and this is going to take a second to explain, but I think it's really crucial.
So Matthew, can I just?
Yes.
Oh, sorry.
No, go ahead, go ahead.
The chart on the previous, the graph on the previous that's talking, the next one more back, that's only 18-year-olds on that. Is that right?
No, sorry. Thank you. Good question. This is total. These are youth in DCF custody of all ages. The orange is meant to represent when there was an additional year's worth, that's not the right.
I would say.
When 18-year-olds were eligible for that custody.
Well, this is the number of kids of all ages that came into DCF custody as a result of a delinquency petition. It's not chins, right? And so that is specific. That's all of them under a delinquency petition that came into DCF
Right.
custody on those years.
And I don't know how many of these are 18-year-olds. It would be interesting
Okay.
to know. Yeah.
So that question then relates to, I'm trying to figure out how on the next page
Mhm.
that relates to those numbers.
Great question. Great question. I think the short answer is most of the delinquencies obviously are not taken into state custody.
Right.
For good reason. Like the state doesn't need to become their legal parent. They've essentially committed what would be a misdemeanor if they were an adult, a small infraction. A lot of these young people are, as we'll talk about in the next couple of slides, diverted, and the state doesn't need to
They
take.
don't have a DCF caseworker though, or that there's not
Correct,
a case
correct.
plan for
Correct, and that is
services or.
exactly, that gets back to the probation numbers on the previous slide. This chart, it would be great to have numbers from DCF that updated about probation counts broken down by age, and to know which of those youth were solely as a result of raise the age. Some of the youth on probation also have dual child welfare or CHINS involvement.
Right.
So the data is hard. It's not simple, but
Chair, what we would want to see is the actual disposition of the filings and use that to create a chart, right? So what was the result of the filing? Because I think when we just see the filing data, it creates this really inflated picture.
That's what I'm trying to get at. Yes, thank you.
So that data request is trickier to get the disposition of each of these 1,009 filings, for example.
Which seems very odd to me, I'll be honest, given the fact that you can tell us, what charge was filed or where it was filed, but you can't tell us what happened to it at the end.
it's available. We
I
hope to bring it back for you. We have a request in.
Yeah.
It is not unobtainable.
was being facetious.
Okay. I never doubt it.
I just, it's not, there's no logic there.
Well, if there's strategy there.
Well,
Yeah.
that may be.
Okay, so I just want to walk through this, just looking at the chart, because the chart and the quote are different. So the chart here, this is data we obtained through a request last year with the judiciary. Again, we're hoping to update this. You have months, so this is basically 18 months starting at the beginning of FY 23 and ending at the end of calendar year 2023. Why it is that, don't worry about it. But and then there's two sets of numbers. There's delinquencies for 18-year-olds, and then there's misdemeanors for 19-year-olds. So this is meant to show the intersection of raise the age, phase 1 and phase 2. In other words, delinquencies for 18-year-olds, these are 18-year-olds whose cases were heard in the family court, right? Who came in under raise the age phase 1. And then the column all the way to the right are 19-year-olds charged with misdemeanors in the adult criminal court, because they are, until July 1st of this year, they are not part of raise the age. The point here is that the numbers are about equal, which is to say we know what to expect, which is about 10 delinquencies per month that would come in, probably based on these numbers. 10 additional delinquencies would be filed per month for 19-year-olds starting on April 1st, 2025, right? So it's an estimate, right? But I think it's interesting that the numbers really kind of come out to be similar. And then if you look at the left quote, this is from the 2019 Act 201 implementation report. Essentially what that says is partly what Lauren was just talking about, and what others were talking about is, okay, what happens after the charge, right? How many of these youth come onto probation caseloads? How many of these charges are just diverted out? There's a whole thing in the Act 201 implementation report about fine-only cases, which exist in the adult criminal docket. That's when, you have an infraction, you pay a fine, and you're done, right? Some of you in this room, I'm not looking at any of you, don't worry, probably have done that, right? And so, the question is, what's the analog when that comes over to 18-year-olds, right? Because a lot of those cases, they don't need to be on a DCF caseworker's caseload, right? They need to be dealt with and then sort of move on, right? So anyway, the point is that if you're, I need a power. The point is that if you're looking at, if you are looking for actual data that's going to tell you about how the system works and doesn't work, that's what you want to know. You want to know, for these average 10 cases that are coming onto caseloads, what's happening and how does that burden DCF? What community services do we need as a result, et cetera, right? And so this is data that we're missing and that we would like to see as I get tangled up in my cord.
I think I would also add, thinking back to what Ben described in terms of the length of this process, that's also key to think of. And some data we don't have is what does the discharge processing look like, right? Like, what is the length of time a process will take for a 17, 18, and 19-year-old? So essentially, we're not seeing 198 in that total period always on a caseload, right? We are going to see youth that are successfully discharging being removed from the caseload. And that is data also that we haven't seen. And I think that will show too that there's not an increased burden on the DCF caseload.
And the whole point is, like, this has to be individualized, right? And when I say has to be, under the Americans with Disabilities Act, right? Under the OJJDP, right? Under federal statutes, like, this is not just like, well, here's what we got, do your best, youth, right? These are federal statutory, constitutional, state statutory. You have to provide services to youth that meet their actual needs, right? And not in an overly restricted setting. So here's sort of a summary of what we said. I think I'm just gonna probably move on. But this slide kind of summarizes, why Raise the Age is actually successful. And I think one thing that's interesting to note is we've had Raise the Age phase 1 for some time now. And, I don't know about you, but I have not seen, this like chart or data or testimony or anything that says it's been the sky has fallen and it's been a disaster. What I consistently hear, which is a very real thing, is DCF is maxed out, overburdened, needs support, has vacancies, needs a data system. All of those things are very, very true, right? Those are true. And those are the things that we've always said. We testified a year and a half ago about some of these issues. Those are important issues and they deserve support, right? And our office partners with DCF all the time on that stuff. We're working on, we have a grant that we'll find out about next week that would bring a whole bunch of federal 4E money, including for the data system, to DCF, right? Through federal sources. So we're here to work on those issues. Those are hard issues, but those are not Act 201 DC Raise the Age issues, right? And I think this afternoon here, sounds like there's going to be an omnibus bill introduced that's going to propose walking back on some of these important reforms. And when you hear that, I would just ask you to keep in mind, what youth need, right? And I would also, I think, take this opportunity to say, like, it would be great if we could hear from the youth themselves. That is often missing and it is incredibly valuable. So
Matthew, I just want to do a time check for you. We will have a lunch break and I see you have quite a few number of slides left to do and just wanting to make sure you get to the things that you think are most important to your testimony.
Stop asking questions.
So what we may, we can go as far as we can by noon, and could also have you back for a little longer right after the floor as well. But I will check with the state's attorney, see how long they need. So, but we'll figure that out, but please proceed.
I appreciate the time check. And thank you for your interest, and sorry for, we're passionate about these issues, as you can tell. So speaking of which, Lauren.
No passion.
This is your passion slide.
I think we had talked about it previously, but it's really important to note, why are we doing Raise the Age? What do we know? What's the purpose of it? And what we're trying to do is reduce contact and reduce recidivism, improve public safety for a child, and then through adulthood, right? Let me take a drink. I think what we know in terms of juvenile justice is that experiencing child abuse and neglect increases the likelihood of juvenile justice contact, right? And so the federal report of maltreatment from the Administration of Children and Families just came out with their 2023 NCAMS report. And the number of victims per age in Vermont made me almost fall over because it was not what I was expecting. And it's not necessarily the number of victims, but it's the age of victims. So in Vermont, 14 and 15-year-olds have or represent the highest number of victims per age group of child maltreatment or child abuse and neglect in Vermont. And there's some, you can attribute that to some degree of how we, investigate child-on-child allegations and out-of-home perpetrators. But I really think that's important when we're understanding what youth in Vermont need and really why we are continuing to enact Raise the Age. So we have 14 and 15-year-olds representing the highest number of victims in our DCF child victim reports, right? And then we weigh that with knowing that more than half of children in foster care will face arrest, conviction, or detention by the age of 17, right? So we've already started this process. We can see Vermont trending the way the national averages go, right? And then we know for children who experience 5 or more placements in foster homes, there's a very high likelihood, if you say 90%, of juvenile justice involvement. We have the DCF Child and Family Service Review of 2024 that just came out. I encourage you all to read that report because that is the indicator that DCF performed most poorly on. And even we talked about it in our Building Bright Futures Spotlight Monday's webinar, right? That this indicator of permanency and placement stability is where we are performing the worst. And then, so I tie that to our juvenile justice system now, that 5 out of 7 Red Clover admissions thus far since December, or this is as of December 2024, were 14 and 15-year-olds, right? So I'm already seeing this pipeline of how our child maltreatment system is feeding our juvenile justice system, and then they're ending up in incarceration. And I will also note that 5 of the 7 Red Clover admissions as of December also had current or previous CHINS petitions.
Yeah, so if you look at the Youth Risk Behavior Survey, which I know a number of you have, these are young people who really are crying out for support. And that's didn't come out quite right because it's sort of like a hallmark way of saying it. But I mean, young people, when they hit the juvenile justice system, it's a moment in time when we can really step up and support them, or we can, to go back to your earlier question, Chair Lowen, like we can criminalize them. And that's on us, right? It's on really us, like the actual people in this room. Just real quick, we'll move fast, but this is from the Vermont Intelligence Center. This is shows offenders and victims of gunfire injuries. And I mentioned Isaiah Rodriguez earlier. The offenses in recent years have ticked up here and there. I think it's been overblown the extent to which violence is out of control. There's certainly some high profile issues. But you see here that the 35.7 line there is victims under 21 involved in gunfire injuries. And that is really concerning. All right, so just briefly on restrictive settings or locked facilities, this is a great quote from Liz Ryan, who I believe is still, for another little bit, the top juvenile justice administrator. Youth prisons are immensely expensive, immensely racially unjust, rife with abuses in Vermont and elsewhere. They continue the institutional legacy of Vermont. If you've read Vermont for the Vermonters, some of you in this room, have done incredible work with disability rights. Youth prisons are some of the most unjust places we have, unjust state-sponsored institutions that we have. whether or not they're necessary, I mean, we should all agree that they should be used in the most minimal way possible. Here's some research. I'm going to keep moving. Here's some racial injustice statistics nationwide. This is youth incarceration per 1 million youth. I'm going to keep going in the interest of time because there's some things I want to get to. These are Vermont numbers. These are Department of Corrections numbers of young people who were incarcerated, so in adult facilities. And, I would recommend later looking at these numbers. What they show is that youth incarcerated are even more racially, youth are incarcerated at a disproportionate rate. Black and brown youth are incarcerated at a disproportionate rate in youth prisons, even compared to the adult prison population. So the bottom bullet is the adult prison population in Vermont, right? And youth prisons are much more racially disproportionate than adult facilities. And this is the case nationwide, right? This is a consistent phenomenon. There's some other numbers too that show that Black and brown youth are charged at younger ages with delinquencies than white youth. The white numbers, sort of as they get older, there's more charges. The Black ones are backwards. They start like the highest numbers at 14 and then 15, 16. I don't fully understand that, but it is interesting to note. This is from these huge reports called Sticker Shock, that one was done in 2014 and one was done in 2020 by the Justice Policy Institute. The cost per youth in 2020, when Woodside was closed, was $528,000 a year per youth. And we are almost.
Is that an out-of-state placement?
No, that is in Vermont. That's what Vermont. Again, it gets back to Vermont being
Vermont cost, but placement, because I know they're placing a lot of people out of state, a lot of youth out of state.
Youth are not, with a couple of exceptions, youth are not usually incarcerated out of state, with a couple of exceptions, not long term.
When you use the word incarcerate, can I just make sure I understand what you mean? Because I think that we'll hear different terms being used by the department, and I just want to make sure we're all speaking with an understanding of what you mean.
Locked facilities, a place like Depot has time delay locks. That's not what we're talking about. A residential treatment program might have time delay locks. That's not what we're talking about. We're talking about locked facilities. Red Clover, proposed Green Mountain Youth Campus. The only one in existence in Vermont right now is Red Clover, but you know more about
DCF will
this.
say secure crisis stabilization or secure long-term treatment. That is synonymous with youth incarceration.
That's where I'm trying to figure out in 2020, since we didn't have Woodside.
Until
Then.
October.
Huh?
Until October.
Right. So I'm just trying to figure out where that,
Those are based on Woodside numbers. This report came out in 2020.
based on Woodside numbers. Okay, that was my question.
I'm
Thank
gonna
you.
call on you, but I don't think I'm.
Representative Harvey.
The 528,000, is this reflective at Woodside? What facilities is this reflective of? And what goes into the 528,000? I mean, that just seems like an astronomical.
It is an astronomical number. The citation is on the last page. I believe it is, everything from the built facility to the salaries to the, raw material, like to the food, et cetera. The total cost of maintenance of maintenance and operation.
But this is the increase at Woodside.
Correct.
From 224,000 to 520,000.
Correct.
Okay. I just want to make sure that I'm
Yes.
fully understanding that.
Yes. And those are both cited at the end. I recommend taking a look.
So we need to end now, because some people have noon.
Okay, can I say two more things and then
Well, I'm gonna have you back.
after lunch?
No, after the floor around 3:30, are you available?
3:30 may not be. I have some children of my own that need to be picked up. So if it's really 3:30, I can make it work, but I'm not sure you can promise us that. Could you give us 5 minutes? Because I honestly think that you guys are.
I know I have a noon meeting that I have to go to, and
Okay, we'll come back, some version of us if it's.
some versions, yeah.
Earpiece.
But, yeah.
You don't want to. You'll be.
I appreciate that.
I appreciate your patience, everybody, and your time and your questions. Thank you.
Thank you.
Thank you.